Well, good morning and welcome to this presentation by Green's List with two excellent juniors from our list. I need to say our list because my name's Simon Wilson, and a number of people have come up to me this morning and said, "This is very good of you to come across and host this on behalf of Green's List." I said, "Well, no, I'm actually on Green's List now." And so for those of you who know me but may not know that I did some months ago move lists, and I'm now very pleased to be on Green's List. I need to also tell you that even after being a silk for 22 years, the topic of today's lectures still looms large in practice. Some of you may be familiar with the recent trial and a subsequent appeal that took place between two gentlemen who'd lived together for 14 years and then decided that they'd have a fight over the approximately $30 million worth of art that that one of them had accumulated. And in the context of that case, when you deal with de facto property, the law of course presumes that there's no wrongdoer. So you don't start with the presumption that someone's done a wrong to somebody else, either by a breach of contract or a tort of some sort. And the question then arises is, if you get one particular party that's particularly difficult and doesn't want to settle and wants to run the case and force the other party to expend huge amounts of money, how do you protect yourself on costs? And because those types of cases involve all sorts of issues in relation to property, it's not easy to deal with them under the regular rules, which no doubt you'll hear about today, offers of compromise rules. It's almost inevitably done by way of Calderbank offers. And because the case law in relation to de facto property cases, certainly whilst they were in the jurisdiction of the Supreme Court, meant that you could, the sort of issues that the courts would look at would be, what sort of offers did the party make? Was their conduct reasonable in terms of the way they ran the case? What proportion of the total pool of assets did the successful claimant achieve at the end of the day, and whether their costs should be reflected by a similar proportion of success and so forth. And in the particular case I was doing, where we were lucky enough to be successful, the question arose because up until about 2 weeks before trial, all of the offers had been extraordinarily complicated, and if I may say, the solicitors had drafted the letters of compromise in a way which really, there were discussions about which painting would go to who and so forth. And it was very difficult to fix on the question of reasonableness as to whether or not a party would have been reasonable or unreasonable in rejecting the particular offer that was contained in the offer of compromise. And so, as a result, I'd said to our instructors that I thought it was just simpler just to pick a figure, work out what proportion as a cash sum you're prepared to make. And so an offer was constructed in that form, and at the end of the day, the plaintiff in effect fell well below that offer. And the question then arose as to what we were going to do about the costs. Now, the judge was very critical of both parties because they'd both been very deleterious in the way in which and to some extent dishonest in the way in which they'd run the case up until the point of that, say, offer, a couple of weeks before trial. And as a result, he ordered that, as a part of a reflection of our success, that we should only have 50% of our costs up to the date of the offer. And then I think after the date of the offer, he gave us 75% of our costs. And the question was, we did ask at trial whether we could have indemnity costs, and we didn't get indemnity costs. And one of the reasons we didn't get indemnity costs was because the way in which the Calderbank letter was structured was that where you get to the usual tail end attributions to Calderbank and cuts and head and so forth, and say this letter will be used on the question of cost, it didn't actually say we will seek indemnity costs. Now, there was a reason for that, but it was because in that type of case you'd be lucky enough to get any costs, and the question was what proportion and so forth. And also, as I said, there are a lot of other reasons the judge would never have given us indemnity costs. But it's a little lesson even now that you can, if you're going to use Calderbank letters, make sure you certainly put into them the type of costs that you're seeking, which will usually be indemnity costs. Now, in cases where there's a wrongdoer, then there's a number of cases which you may hear about today where the courts have said, oh, well, the fact that you don't say you're seeking, everyone knows, lawyers know that that's in effect what the effect of non-acceptance of the offer is. And So in some cases where there's a wrongdoer, you'll get it, but in other types of cases, which are obviously not so regular, you'll find that you need to be quite clear and specify precisely what it is you're going to seek in costs if there's an offer that's unreasonably refused. Now that then brings me to introduce our speakers today, and I'm going to do it in two halves. We're going to have a break between speeches, and so the first speaker today is Adrian Muller. Now Adrian was admitted to practice in April 2003 and he signed the role in 2010. He practices in corporations law, commercial litigation, corporate and white-collar crime, equity and trust, property, trade practices and consumer protection. In short, he's an excellent general advocate. Adrian has a reputation as a reliable, hard-working and committed advocate, and he's appeared in trials in nearly all jurisdictions in Victoria and in the Commonwealth. He's also advised and represented corporations and individuals in the Australian Securities and Investments Commission, examinations and investigations, as well as advising and appearing for ASIC. I think it's fair to say he understands sensitive client issues, which is of particular benefit when advising on compliance issues, including under the US Foreign Corrupt Practices Act and the UK Bribery Act, bribery and corruption, risks, conflicts of interest and legal professional privilege. He's also experienced in alternate dispute resolution, not something that Senior Silks favour, processes including negotiations, mediations and arbitrations. And Adrian read with Ted Woodward SC, so let me introduce Adrian Muller.
Thank you, Simon. It's always nice when you hear that list to realise where the last decade of your life has gone. I was articled, as Simon said, to a wily old litigator named Rob Lees at Slater and Gordon, that disreputable firm that most of us know about. And Rob was one of those people who always looked first to the opportunity that you could get with the most certainty. And so when it came to making offers, his view was to make an offer of compromise if at all possible, and to make it as early as possible to give the client the best possible protection. Simon's story is a good example of a situation where you wouldn't do that, because when you consider the circumstances of a particular case, it was clear in that situation that a Calderbank letter would be a better way to go. But it's remained impressed in my mind that the first thing that one should do when one's looking at offers of compromise and Calderbank letters is to think, can I use an offer of compromise in this situation? That view has been strengthened with the substantial changes that have been brought in since September last year in the Supreme Court, October last year in the County Court, and from 1 August of this year in the Magistrates Court, such that the offer of compromise regime, which is found in Order 26 of the Supreme Court rules and substantially replicated in Order 26 of the Magistrate Court rules 2010, to strengthen and improve the offer of compromise regime under the rules. So first, what I'd like to do is give you a summary of what those changes are, and then I will talk a little bit about the mechanics of making an offer of compromise. But in a paper that we've prepared, I've set out in some detail the mechanics and also a detailed comparison of the difference between offers of compromise and Calderbank letters. And then what I would like to do is to just give you a couple of tips. And Simon likes to talk about the cases where he's been a winner. I'm going to talk to you about a case where we lost on every point, but because of the way the Calderbank letter of our opponents was drafted, the client ended up getting substantially what they wanted. So that's a tantaliser to keep you awake while I talk about the rest of the stuff. So let me start first with the summary of the changes that have come in, as I said, from September last year, and they are not retrospective. So if an offer was made in the Magistrates Court of Victoria, for example, in July of this year, then that would be governed by the old regime, and if you've done that, you might be well advised to repeat the offer under the new regime now that we're into August of 2010. The first and perhaps the most substantial change that will rewrite what most of you know about offers of compromise is that offers of compromise in the Supreme Court, County Court and Magistrates Court can now be expressed to be inclusive of costs or to be costs to be paid or received in addition to the offer. So that changes the previous position in the Supreme Court, which was that an offer of compromise always had to be expressed exclusive of costs, and brings it into line with the situation in the Federal Court under Part 25, where you could make inclusive of cost offers. The second major change is that an acceptance of an offer of compromise may be withdrawn if the money is not paid within the time specified in the offer or within 28 days of acceptance of the offer, and the court gives leave to do so. And then a party who seeks leave to, or seeks orders to restore the, party who seeks leave can also seek an order that the parties be restored to their previous position at the time of acceptance, and orders about the conduct or further conduct of the proceeding. And then if a party defaults in complying with the offer after its acceptance, then a non-defaulting party can also ask for an order giving effect to the offer, so a compelling payment, or an order staying or dismissing the proceeding if the plaintiff is in default, or an order striking out the defence if the defendant is in default, or, if you need to, an order that the claim or part of the claim not subject to the offer proceeds. The proviso on that, or the caveat on that, is that where there are multiple defendants, the rule's limited to where the offer is made to compromise the claim against all of the defendants. Another minor change is that the consequence of non-acceptance commences at 11 a.m. on the second business day after the offer was served, instead of the day after the offer was served. And another important change, particularly where defendants are making an offer of compromise, is under the old rule regime there was really no benefit to a defendant if they made an offer of compromise and then the claim was wholly dismissed or there was judgment in favour of the defendant. There was no additional cost benefit for the defendant under an offer of compromise in those circumstances, and that's another situation where traditionally you would have used a Calderbank offer rather than an offer of compromise. But the rules now provide that where an offer of compromise is made by a defendant and the plaintiff unreasonably fails to accept the offer and the claim is dismissed or judgment is entered in favour of the defendant, then unless the court otherwise orders, the defendant shall be entitled to costs on the usual basis up until 11 a.m. on the second business day after the offer was served, and thereafter on an indemnity basis. And just stopping there for a moment, because that picks up one other thing that I wanted to mention in passing, and I deal with it in the paper, is that one of the big advantages of an offer of compromise is that the onus or the benefit of the compromise falls in favour of the person who's made the offer. So the court looks at the offer of compromise and then asks itself the question, is there a reason that costs shouldn't flow in consequence with the rule? Whereas under a Calderbank offer, it's up to the offeror to establish or submit to the court that there is a proper basis for the court departing from the usual cost order, which is costs on a standard basis, the old party-party basis situation, to some other cost regime. Another significant change is that offers of compromise used to be limited to offers being made on a claim in a proceeding, so they couldn't be used before a proceeding had commenced. The rules now provide that an offer of compromise can be made prior to a proceeding commencing. The offer has to be left open for a reasonable period of time for acceptance. In the Magistrates Court, that's specified as 7 days. In the County and Supreme Court, it's said to be the reasonable period. But it's something that parties can really think about before they even issue proceedings now, is how to make an offer that would best protect the client, potentially through the whole of the conduct of the litigation. And the other substantial change is that offers of compromise are now extended to contributor parties that may be held liable to contribute towards an amount of debt or damage. Now that in essence means that defendants and third parties can make offers between themselves, and there are cost penalties or cost benefits in association. It's a complex scenario, and if you're in that situation where you're looking at making offers where you've got contribution issues, then you need to be mindful of the proportionate liability regimes and the provisions of the Wrongs Act. But the rules now establish a process where you can actually go and use the offer of compromise regime for those sorts of offers. And as I said, the transitional provisions provide that it's prospective, not retrospective. So if you're involved in litigation, particularly probably now if you've been involved in litigation since the rules came into this operation in the Supreme Court, then you may well have thought about making further offers in any event, but particularly in the Magistrates Court at the moment, you might be well advised to re-put those offers if there's benefit to you in making them under the new rules. And in the paper I've set out in a bit more detail what those changes are. Let me talk very briefly about the mechanics of making an offer of compromise, because it's important that the mechanical provisions that are set out in the rules are complied with. Otherwise, what you can find the situation to be is that the court will say, well, it's not an offer that is compliant with the offer of compromise regime, but the court may then be prepared to look at it in terms of whether it is effectively a Calderbank offer. But the difficulty for that is that then you have to have an argument about whether that's actually a proper Calderbank letter, and also the burden of the benefit of the cost order shifts from one that is, I won't say automatic, but one that is heavily in favour of the offeror to one where the offeror has to establish that there's a good basis for the court departing from the usual order as to costs. So the first thing to do is make sure that you comply with the requirements of the rules, and that's to set out the offer of compromise on a court heading with the names of the parties, and you use the usual forms to do that. The offer has to specify that it's made under Order 26 of the rules. It used to be that the offer had to be expressed as exclusive of costs. That's not the case now, but you do need to specify now whether or not the offer is being made exclusive of costs or whether the offer is being made inclusive of costs. And pausing there to just make a comment about that, one of the things that you want to look for is if you need to rely on your offer of compromise at the end of trial, it's at that point that it goes before the court, and the court has to have an ability to assess the offer as against the result, because it's only in circumstances where, to use an example, where the plaintiff has made an offer that the defendant hasn't bettered the offer, that the plaintiff gets the benefit of the costs order. So the plaintiff needs to be able to establish to the court that the defendant didn't better the cost order. Now, if the offer of compromise is for $100,000 plus costs, which was the old regime, of a claim that was for $200,000, then the plaintiff would have been in a position of saying, well, it was a genuine offer to compromise, it was 50% of the claim. And if the defendant received an order for $80,000, then the plaintiff can very clearly say, well, I bettered that offer. The defendant didn't better that offer, so I should get the benefit of the costs orders. But if that offer is now expressed as $120,000 inclusive of costs, and the plaintiff receives $80,000 at trial, then the question becomes, well, has the offer been bettered? How much of that 120 was the cost component? How much of it was the compromise of the preceding component? So it has some attraction to practitioners, because when we settle matters, we often want to just roll everything up and settle on an all-in sum, and that there's a lot of good reason to do that. But when you're thinking about the tactical use of an offer of compromise, you need to be mindful of those sorts of issues. Is at the end of it, how are you going to be able to say to the court, the other side didn't better the offer that we made? Now, sometimes that will even with an inclusive of costs offer, be readily apparent. Other times it won't be, but that's I encourage you to give thought to those issues as you're preparing your offers. Exactly the same can be said for a Calderbank letter as well, is that if you make the Calderbank letter inclusive of costs, you have the same issue. The other thing to bear in mind, and it's probably more relevant for Calderbank letters than for offers of compromise, is that the offer has to be clear and capable of being accepted by the offeree. And most of the time where it's to accept or pay a sum of money, that's relatively straightforward. But using an offer of compromise process doesn't preclude you from making other offers. So in the example that gives rise, or the case that gives rise to the name Calderbank letter, the case of Calderbank and Calderbank, the offer that was put was to transfer a house from the wife to the husband in matrimonial dispute. Now there is nothing precluding that offer being made under the Order 26 proceeding. That would be to compromise the proceeding by transferring identified property from the wife to the husband. And that would be an offer that is clear, it's capable of being accepted, but it wouldn't be capable of being accepted if, for example, before the wife could transfer the property to the husband, she had to obtain title to the property for someone else. So that would put a step in that would make it impossible for the husband just to accept that offer and have the certainty of it in those circumstances. Another requirement under the Supreme Court rules, it's not the same in the County Court, is that the offeree has to acknowledge receipt of the offer within 3 days, and they have to do that in writing. And again, that was something that my principal impressed on me as a practitioner, was important to make sure that you got the acceptance, because you don't know what's going to happen down the track. You don't know whether the same solicitors will stay involved in the other side. On the other side, you don't know whether when you get to relying on the offer of compromise or the Calderbank letter, you're going to be met with the other side saying, we never received that. And the way the rules deal with that is to provide that written acknowledgement has to be received in 3 business days. If you don't receive it, you're entitled to write and say, please acknowledge receipt of my offer of compromise. And that removes that risk from you when you go at the end of the proceeding, which can be months or years later, to rely on the terms of that offer. When you're drafting or considering making your offer of compromise, and it's the same for a Calderbank letter, there's 2 things that I'd urge you to think about. One is to think about the end game, and that's what I'm going to talk to you about in the context of the case that I was involved in. And the other is to think about the long game. And by that I mean that, particularly now that the rules provide for you to make offers even before a proceeding has commenced, that you might have a client who's about to embark on some litigation where they will, they're suing for $200,000. And you know that the cost of pursuing that $200,000 is going to be substantial. It will be, at best $30,000 or $40,000, and that absent any offers, they're unlikely to recover more than half to 2/3 of that. So making an offer early to compromise the proceeding, even if it's only for the difference between what the solicitor client and party costs would be, starts to give your client a real edge in protection, and starts from the very outset to put the other side at risk that if they don't properly assess their situation and accept reasonable offers or make reasonable counter offers, that they're at risk of penalty cost orders right from the commencement of the proceeding. And that's a well crafted and well put. It's a very powerful tactical tool that you can have in your bag of tricks. And the other is to think about the end game. And by that I mean to think about how's all of this going to look when we have to produce particularly a Calderbank letter to the court and argue before the court that there should be a penalty cost order made in our favour because of what's put in the letter. So the circumstances that came about in my case were I was acting for a financial services provider, and they were in a dispute with one of the dispute resolution services that are set up under the Corporations Act. And what had happened was that there had been a disagreement between my client and the dispute resolution service about some decisions that the dispute resolution service had made and the way that they had gone about making those decisions. Now, in short compass, that's a very difficult claim to bring because the basis of it is contractual, not administrative law, and the parties had bound themselves in contract to accept certain outcomes. But my client felt particularly aggrieved by the conduct of the dispute resolution service, and so when the dispute resolution service, so it sought to end the relationship and move to another provider. The dispute resolution service responded by suing for unpaid fees on a number of the disputed files where my client had taken issue with the conduct of the way those files had been managed and the way decisions had been made. What my client really wanted was vindication. They wanted the dispute resolution service to acknowledge that it had made mistakes and acknowledge that it ought to have done things differently. The dispute resolution service fought the litigation hard and ultimately were successful both on suing for their fees on the claim and defending the counterclaim that my client had brought, which was in essence for the breach of contractual obligations to do things in particular ways. In the course of the litigation, the dispute resolution service had written to my client and offered to compromise the proceeding by way of a Calderbank letter, and part of the offer was that the dispute resolution service would make a private apology to the head of 4 banks. My client rejected that offer and continued on to trial. And as I said, we were completely unsuccessful. So Simon, it's unusual for us to talk about unsuccessful cases, but...
I don't remember any.
The dispute resolution service then sought to rely on the Calderbank letter. And we objected to that on the basis of there were various grounds that that we said made the offer that they'd made not unreasonable to reject. But the difficulty for the dispute resolution service was that in order for them to rely on their offer, they had to put the letter into evidence so that the court could consider it. And that included the apology that they had offered to make to the 4 banks in complete privacy and with confidentiality clauses attached. And then, even though they were successful ultimately in getting their costs from the date of the letter on an indemnity basis, what happened was the judge, as is the practice in some of these matters now, attached a copy of the Calderbank letter to her judgment and made reference to various parts of the letter, including saying that, referring to the offer of apology, albeit with a restricted use, was also to be taken into account as one of the factors. That then got picked up by various financial services, wire services, who, with their usual lack of complete accuracy, reported that the dispute resolution service had made an apology to my client. Well, at that point, my client was over the moon because they'd effectively got everything that they'd wanted, even though they'd completely lost the litigation. All of that could have been avoided if an offer of compromise had been used rather than a Calderbank letter, or if an offer of compromise and a Calderbank letter had been used at the same time, so that when it came to the end of the proceedings and they wanted to get the benefit of the costs protection, they could have relied on an offer of compromise rather than on a Calderbank letter that had all this other detail in it. So it's very important that you think about what's the end game going to be for the client if we have to produce this letter in court. Now that's an extreme example, but other examples include be careful about the language that you use, the way you phrase the offer. Is it going to read to the court like you're trying to bully your opponent into accepting an offer? Does it read like all you are doing is inviting your opponents to capitulate and pack up their bags and pay your costs and go home? Those things matter when you put the letter before the court and the court looks at it and says, why should I give you a favourable cost order based on this letter? That's all I wanted to talk to about the paper at the moment. The paper will be distributed by email hopefully later today, if not tomorrow. Otherwise, I think now Simon will have a short break.